Though we are hundreds of miles away from Washington, D.C., you, my judges, are acting as congresspersons today. You are tasked with defending America's interests, representing your local constituents, and you must make a prudent policy decision on behalf of your constituents. The question is, would you make that decision without the appropriate intelligence? If there is a risk that your policy will affect the national security of your constituents, would you act without that knowledge? That is not prudent policymaking, and we would hope that you as congresspersons would not, in that knowledge, endanger the national security of the United States of America. In this speech, we're going to be examining about how the affirmative team has failed to prove a tangible harm, but that there will be tangible disadvantages to their passage of their plan. But before I get into that, I'd like to point something unique about military commissions, and that is that they only deal with very high-level terrorists, not common terrorists, but the high-level terrorists. So that's important to keep in mind. So my first main point you can tag as no tangible harm to U.S. citizens. No tangible harm to U.S. citizens. And I'm actually going to be going point by point and looking at the supposed harms of the affirmative teams and show how they're not actually affecting the national security of the United States of America. By the way, national security is the entire reason why we have these terrorists within U.S. jurisdiction in the first place. That's why we have them, and that's why it should be our end goal. But my first main point under this is that there's been no numbers. No numbers. The affirmative team is giving you no numbers on how many terrorists are actually held in Guantanamo Bay. And this is critical, not just because they have the burden to have a substantial reform, because they do have a burden to have a substantial reform. So we don't even know how many people will be affected by their policy, because they can't even give you a number on how many terrorists are being held in Guantanamo Bay. Also, under this point, they can't actually prove what we can't actually have an informed policy debate without these numbers. Now, the affirmative team has said, well, the government hasn't released this. But if you, as Congress, wanted to, you could ask the government to release these numbers and then have an informed policy debate after that. So the affirmative team has chosen to pass a policy without having an informed policy making. My next point is that they can't actually prove there is no closure. They can't actually prove that there is no closure. First of all, because they don't even know how many cases are currently pending. They don't know how many cases are currently pending. Because they don't have any numbers on the amount of terrorists, they don't have any numbers on the amount of cases that are unresolved. They do not have any numbers on the amount of cases that are unresolved. Now, the examples that they brought up, they read a quote from U.S. citizens, and that quote from a family of murdered victims of 9/11, they said that there are many legal challenges remaining. However, there has been more legal clarity since we've started the military commission. There has been more legal clarity. For example, in 2008, in Boumediene versus Bush, the Supreme Court ruled in favor of habeas corpus rights for these detainees. Because we were holding them indefinitely and without giving them a challenge to challenge their detainment, the Supreme Court ruled that that's unconstitutional. So there has been more legal clarity in the current system, and that's one of the main reasons why there was a lack of closure, because they were pending these cases. Now, the next point I have here is basically what is the harm the affirmative team is claiming? Because most of the people who are against military commissions say so because it violates human rights or because it's immoral. But the affirmative team is not contesting this. They're simply contesting that it's inefficient and that it takes a long time. However, what's wrong with holding these terrorists in Guantanamo Bay for long periods of time? Even if it takes longer periods of time, A, they're high-level terrorists, but B, it's not harming American citizens in any way. It's not doing any damage to the national security. They're far away from the American people. Now, the next point they brought up was basically that of other countries, and they talked about international cooperation. They didn't read this piece of evidence, but according to the piece of evidence, it said that Spain, like many other countries, would not extradite terrorists to the United States because they don't want them sent to Guantanamo Bay. But in the part that they did not reference, it says that we were actually able, it's referring to someone called Ali Sharaf Damash in a federal court in Philadelphia. And it actually said that we were able to put him in a U.S. court. And that the reason why I'm bringing this up is that we have flexibility in the status quo. Even if they won't accept it in a Guantanamo Bay court, we can accept it in a federal court. In the status quo, we have the option to choose which of the courts we want to send them to, military courts or federal courts. So even if countries won't extradite them to Guantanamo Bay, we can easily send them to federal courts. So the status quo provides flexibility in the status quo. Once again, we see a lack of any tangible harm from the affirmative team. They've only given you one example where there was a lack of prosecution. In their 1AC, they talked about just deserts, how we weren't able to prosecute the terrorists. However, that was just one example, and that was because the prosecutors made a mistake of saying that there was no material support when it could have been brought up in federal courts. Every single terrorist that we want to prosecute can either be prosecuted in either federal courts or Guantanamo Bay. So under the status quo, we can effectively prosecute anyone we want. There is no tangible harm and no numbers. This brings me to my disadvantages. The first disadvantage I have is that of a national security undermined. National security undermined. And I'd like to first talk about the classified information point. Now, here's the reasoning behind the classified information point. Federal court cases are public hearings. And what happens in a public case is there's what are called pre-trial discovery. Pre-trial discovery is where the prosecutor has the obligation to provide information that is favorable to the defendant. And in this case, the defendant would be a terrorist. And that terrorist, even before the trial happens, can send that information to other terrorist groups who can then use that information and intelligence about U.S. officials. Now, the affirmative team talked about CIPA. However, even with CIPA, there can still be a breach of classified information. I have a piece of evidence here from Ashley Indurf and Wayne Massey, who are students at George Washington University Law School. And they said that under CIPA, the trial judge may conduct ex parte hearings to determine the materiality of classified information. The relevance of evidence and whether that evidence is exculpatory must be disclosed under Brady v. Maryland. However, it is not always clear. The trial judge often makes pretrial determinations without the benefit of the adversarial process and without knowing the defendant's theory of the case. The court may determine that certain evidence is material and that a substitution or summary is inadequate. In such cases, the government would be required to choose whether to disclose the relevant information, accept a sanction, or in some cases, forego the prosecution. And they say that this could result in the possibility of revealing information to terrorist networks. Okay, that was an extremely technical piece of evidence. I want to explain that for you today. What this is saying is that even though we have CIPA, the standards that we use for determining if the government, the prosecutor is required to provide that information is not legally clear. And because of this, it's up to the discretion of the trial judge. Under the Constitution, the trial judge, regardless of whether or not there's a national security harm, sometimes is required to provide information to the defendant if it is considered material. And because of this, the government would have the option of either A, releasing that information and risking their national security, or not using that information in which the terrorist would go free because that terrorist cannot be presented in a trial. So this is still a national security threat. And in the status quo, we have discretion to know when to use this evidence and when not, depending on the particularities of that case. And so that's why the national security would be undermined. The next disadvantage that we had was that of terrorists can abuse the system. And my partner read an example where high-level terrorists went to U.S. court and they proselytized Islam to the other person in jail, and that person became a threat to the United States. High-level terrorists do not belong in U.S. prisons because they can influence other people in prisons, and that can cause further radicalization. If you look at France and Germany, they've had the same problems with putting terrorists with other people, and that has caused mass problems. But the final point I'd like to bring up is a slippery slope. What will be the legal protections for terrorists when they're in the United States? Will they face full constitutional protection? And if so, will that harm our national security? We do not know the answers, and that's why we ask you to vote against the policy as prudential policymakers.